So the judgment is ready, and due to time constraints, we shall not go through the facts, the pleadings, and the submissions. We just go to the analysis and the determination. Is that okay? Okay. Oral submissions of land issues falling for determination to be as follows. 1 is the constitutionality of have been implemented. For example, gazettement and swearing of members of the ad hoc political parties dispute tribunal. Many parties have done their primaries and nominations. 5, counsel for the 2nd to 5th petitioners is calling on this court to strike out the amendments based on conjecture, hypothesis, and speculation. Our finding, therefore, is that the 2nd to 5th petitioners have failed to prove any vagueness or uncertainty in the impugned amendments, which are very clear on their intent. We find nothing to make us strike out the Political Parties Amendment Act on this ground. Whether the petitioners are entitled to the orders sought. We think we have said enough in respect of the prayers sought by the petitioners, and our findings are as follows. 1, there is no unconstitutionality in the amended sections 2, 4A, 62A, 76, 14A, 22, 34, DA, B, FA, FB, FE, 40, subsection 3, 41, subsection 2 of the Political Parties Amendment Act 2022. 2, there is no unconstitutionality in section 28(1) and 28A of the Elections Act. 3, the deletion of section 31, subsection 3 of the Principal Political Parties Act is unconstitutional. 4, section 34 FD is unconstitutional, as regulation of political party nominations is the mandate of IEBC and not the Register of Political Parties. 5, we find that the public participation that took place before the enactment of the impugned amendment was consultative, meaningful, and reasonable. The amendments cannot therefore be nullified on this ground. 6, the impugned amendments do not render the Principal Political Parties Act ambiguous, uncertain, or vague. 7, save for what we have found in respect of sections 31, 3, and 34 FD of the Political Parties Amendment Act 22, the petitions fail and are dismissed. And on costs, we have considered the issue. Costs generally follow the event and are in the discretion of the court. However, in the circumstances of this case, we find the order which commends itself to us to be that each party shall bear its own costs. Those are the orders of the court, and you will give.
The judgment was today, and what it means for the petitioners.
Yeah, this was a case about the recent amendments, for example, to the Political Parties Act, and the court framed about 5 issues. One was about constitutionality of some provisions of the new act. There were issues about whether there was public participation. There was the issue of whether the act was ambiguous on the question of what is a political party vis-a-vis what's a coalition, vis-a-vis what is a coalition political party. And then there was also the question of whether the petitions then would succeed, and eventually what the remedies would be given in the petitions, and lastly what the question of the costs. So the court was very clear that there was no unconstitutionality in the provisions of the act. I think, but there are just two issues where they found there was some on the concern, but those are the matters which can easily be handled. For example, they talked about the issue of audit, that the audit should still be done with respect to coalition parties. There was another question of the role of IEBC vis-a-vis registrar of political parties with respect to nomination. And again, that one is an issue which, reading the constitution and reading the act, there isn't a big problem there. So this was a success for the recent amendments, because it was very clear that they said that the amendments were constitutional. They said that there was public participation which lasted for at least 4 years, and that it was meaningful. Actually, they used the phrase meaningful public participation. They also said that there is no ambiguity at all. There is no incoherence. There is no overbroad definition in terms of when you compare what a political party is, what is a coalition of political parties, and what is a coalition political party. So there is no ambiguity. So that means that the processes which have been going on regarding coalitions are okay. And actually they also clarified that the fact that you belong to a political party or a coalition political party does not deny you the public participation or participation in your political rights under Article 38 of the Constitution. Yes.
So basically that's just about it. So those are basically the issues that the petitioners were raising, most pertinent issues.
Yes, and then they said also that the costs, everybody would bear their own costs. They use the phrase that the costs follow the event, but the court has discretion. So everybody will bear their own costs.
All right.
Yeah.
Thank you.
Thank you so much.
Any other questions? All right.
Okay, thank you so much.
Sorry, can we just get your full name? So
yeah, my name is Ben Sihanya. I'm a constitutional professor and advocate, and we were representing here as Azimio. Yeah. Yeah, thank you so much.
Thank you, Prof.
Of the Political Parties Amendment Act. To a larger extent, they have declined to allow our petition, but they have declared two sections of that act as being unconstitutional. One is section 31, 1A, that had the effect of exempting political or other coalition parties from audit from the Auditor General, because coalition parties are also funded by taxpayers' money, so there wasn't any reason as to why they were exempted. So to that extent, that provision has been declared unconstitutional. The other one is section 34 FD, which had created a sort of a conflict between the role of IBC and that of the Register of Political Parties, especially when it comes to matters of regulating nominations exercise. So to that extent, again, the court has said that that is a mandate that cannot be taken away from IBC by dint of Article 88 of our Constitution. So that mandate squarely rests with IBC. The other issues have not been allowed, especially the issue of whether a coalition party is constitutional in its nature and whether it conflicts with Article 38 of our Constitution. I'm here to seek instructions from my client, but I have a feeling that we might be proceeding to a higher court, especially on that issue of whether a coalition party is constitutional. Thank you. Iko swali?
Mama wenzangu, so far tumefikisha 350k kwa akaunti yetu ya chama. Tufanye aje na hizi pesa zetu?
Naona tununue vitenge zinafanana. Vitenge. Hapana, tununue sufuria za non-stick.
Tununueni curtain.
Ai, mama wenzangu, vote tununue kaploti.
Kuna watu wanauza plots na nyuki.
Na nyuki?
Hebu tuwapigie simu watupe uhondo.
Hello.
Thank you for calling Optiven. How may we assist you?
Can we get a plot with 350,000 in Nanyuki?
Yes, you can get a plot at the Great Oasis Gardens in Nanyuki today for as low as 349,000 shillings.